Hello everyone. Today I will be talking about the recent Supreme Court verdict in which it was held that equal pay for equal work is not a fundamental right vested in any employee, though it is a constitutional goal that needs to be achieved by the government. Before understanding what happened in this case and understanding the facts and circumstances in this case, we will first understand what do we understand by equal pay for equal work. So, Article 39 of the Indian Constitution provides us with this concept, which has been there under the directive principles of state policy. So, when we talk about this directive principles of state policy, as the sentence suggests, these are the directions given to the state that while formulating any law, while formulating any policy, they should keep in mind these directives. And equal pay for equal work is one such directive. So, from this, we can understand that this concept of equal pay for equal work is not a fundamental right, though it is provided to us under the constitution. It is there under the heading of directive principles of state policy. So these are the directions, these are the things which the state keeps in mind while formulating the law. But what do we understand? What does it literally mean? So equal work connotes the work of equal value. For example, in an organization where there are employees who are at the same position, who are doing the work of similar nature. So, in such cases, irrespective of their sex, color, caste, or creed, all of them are entitled to the same remuneration. From this, we mean that equal pay for equal work. And this principle has arisen from the basic concept of equality. And at the same time, the preamble of the Indian Constitution secures equality of status and opportunity. So this has been provided to us under our preamble. This has been provided to us under our fundamental rights as equality, but specifically, expressly, it has been given to us under our directive principles. So, though it is not a fundamental right, but it is the duty of the state that they should ensure equal pay for equal work. Now, we will come on to the case which we are talking about. So, this case is of State of Madhya Pradesh versus R.D. Sharma. In this case, the bench that was hearing this case was of Justices D.Y. Chandrachud and Bela M. Trivedi. In this case, the writ petitioner, the person who had filed the case before the High Court of Delhi, had retired from the post of Principal Chief Conservator of Forest. And the government of India had rejected his representation seeking revision of his pension from 37,750 to rupees 40,000 as per the Indian Forest Service Second Amendment Rules 2008. So he again approached the Central Administrative Tribunal, which dismissed his original application. Later on, when he reached the High Court allowed his writ petition and held that he was eligible to get this benefit of rupees 40,000 as pension at par with other officers. Then, after this judgment, the state filed the appeal to the apex court, that is the Supreme Court, and the Supreme Court held that the High Court had misdirected itself by applying the principle of equal pay for equal work. And the court in this particular case observed that the equation of post and determination of pay scales is the primary function of the executive and not the judiciary. So deciding these matters related to pay scales is not the function of the judiciary but of the executive. Therefore, ordinarily courts will not enter upon the task of job evaluation, which is generally left to the expert bodies like the pay commission. And this is because such job evaluation, the reason for this was that this whole process of job evaluation exercise may include various factors, including relevant data and scales for evaluating performances of different group of employees, and such evaluation would be both difficult and time consuming apart from carrying financial implications. Therefore, it has always been held to be more prudent to leave such task of equation of post and determination of pay scales to be best to be decided by an expert body, unless there is any issue related to a conclusion, where related to a record where a conclusion is made that a grave error has crept in while fixing the pay scale of a given post, and the court's interference was absolutely necessary. So this is required in such cases where there is injustice, where there is something fishy, where the court's interference is very necessary. Otherwise, the court would not interfere with such complex issue, as it is the duty of the executive to decide such matters. So I hope this video was helpful to all of you. Please do like, share and subscribe to my channel. In case you have any query in relation to legal matters or law exams, you can reach out to me on my email ID or on my Instagram ID. The link for the same is provided in the description below. Thank you very much.